Thursday morning. Today we're going to be talking about elder abuse and particularly financial elder abuse in real estate transactions. Let me share my slides here today, and this will help everyone follow along. If after this webinar you'd like a copy of these, just email me and I'll have my email address, or you can contact the North San Diego County Realtors. So without further ado, let me share my screen. Can everyone see that? Well, let me see here. Make sure I did that correctly. Okay, hopefully you can all see that. If not, somebody please send something in the chat. I want to make this interactive. We don't have a ton of people here today, but we have plenty to have an interactive conversation, and that's one of the things I think is really important. I've done for those of you who this is your first time on one of these webinars, or those who've been here many times, know that I like to try to keep this as much of a flow as possible and answer questions. And feel free to do that by way of the chat, or frankly, I don't mind interruptions. I want this to be useful to you. Because that's really what I'm here for, is to make this webinar as useful as possible. So what are we going to talk about today? We're going to talk about financial elder abuse and how to avoid it. As many of you probably know, this is the sale of homes from elders is becoming a larger and larger share of real estate, and so we thought it was timely. I did this same presentation a couple times over the last couple of years, but it's a very timely with the market and how people are selling, especially during the pandemic, because you may have less interaction with the client than you normally would have. So let's get right to it. First, I'm going to give you my shameless plug of who I am. Some of you may know me well. Some of you, this is the first time you're talking to me or you're hearing me. I'm a partner at White & Bright. Some of you may have heard of our firm. We've represented North County since its inception, and I've been general counsel since 2016. My practice is a hybrid practice, actually. I do transactional work and I do litigation, and I'm defending, so I do purchase and sale transactions on the real estate in residential and commercial. So this comes from both areas. And I do a lot of agent and broker defense, representing small brokerages with one or two agents to large brokerages with 300, 400 agents. And so I see I see kind of the mixture of San Diego County, and almost all of my practice is in San Diego County. So I'm attuned to what we're seeing here, which is sometimes slightly different than what you might be seeing in LA or Northern California. So this is my shameless plug. But please, if you have any questions after this, feel free to contact me. White & Bright. This is our 40th year. We've been doing this for quite a while, and we will continue to do this. So shameless plug aside, what are we going to talk about today? We're going to talk about these issues. First of all, recognizing a red flag in an elder, what I would call an elder transaction. What should you be, why should you be looking for this? We're going to talk about the capacity of elders. We're going to talk about financial, we're going to define what financial elder abuse is, and I'm going to kind of scare you a little bit as to how easy it is to prove. We're going to talk about undue influence and what that means in the capacity, in the context of an elder transaction. I'm going to give you some examples of things that were held to be financial elder abuse. We're going to talk about, obviously, the consequences of what are the parade of horribles that can happen if there is a finding of financial elder abuse, and then I'm going to do what I normally do on almost all my webinars or presentations, is give you actual tips that you can use in the real world. Because some of this stuff, it's great theoretically, but what can I actually do as a realtor to protect myself and protect my clients, frankly? Because elder abuse is, there's a real victim in these. It's not some theoretical, it's not some theoretical exercise. There's a real victim in this, and it's typically the elder. So without further ado, I'm going to go through the presentation. We got about an hour today, and of course, as many of you know, I'm almost always up for questions afterwards. So let's talk about what a red flag is. Some of you have probably attended. I actually have a seminar called Red Flags in Transactions, and one of the red flags that I always highlight is the elder transactions, because what I call a red flag is something that should alert you that there's a potential problem in a transaction. It doesn't mean that there is a problem. It's just something that should alert you that there could be a problem. For instance, it's something like you see cracking on a wall in a home. Well, that should alert you that there may be an issue with the foundation or the structure. That's a potential problem. I would also say that when you have a transaction with an elder, or and what I mean by an elder, I'm not picking on people that are older, but it's the 65 and up. That's what California defines as an elder. That when you have an elder in a transaction, you have a heightened duty. This is a potential problem in the event that they don't have things like capacity. And so it should alert you. You should be, I know some realtors out there, this is all they do. They work with, they call it transition, potentially selling a home and moving into a assisted living facility or something like that. And so they specialize in this area, but there's other agents who this might be, they kind of take what comes through the door, right? And one day it might be an 88-year-old man. The next day it might be a 25-year-old, buying their first home. And so they have this, what you have to do is you have to be attuned that when you're dealing with an elder in some of these situations, that you have to think ahead of this, that this may be a potential problem, or it may be a red flag. Doesn't mean it's always going to be, but it's something that you should be aware of. And so where does a red flag come from? It comes from your investigation, your knowledge, your background as a professional in this industry, knowing through experience that, oh, I got to listen to the parties. Oh, I can see some documentation. And so we'll talk about where this all kind of comes together in the transaction. So here's the background of this whole presentation, is that we have an aging population, and they hold a lot of real estate. There's a lot of tax advantages, as you well know, to holding real estate over time. You can give it to your children, you can give it to your grandchildren. You can without reassessing taxes. There's lots of reasons why people hold real estate, and people hold real estate for years and years. And as you all know, the market's is hot; it's on fire right now. And so there is a ton of money locked up in with people who are over 65. And so this is a vast transfer of wealth from one generation to the next. And so every time you have a vast transfer of wealth, when you got $1 million homes on the beach that are paid off, there's often people who are looking for that, to make some money there, whether it's a caretaker, whether it's, a neighbor, whether it's, frankly, a relative, and often it is a relative. And I'll use that example many times during today's presentation of, or son or daughter who wants mom to move, wants mom to sell her home, and they want to be in charge of the transaction because mom needs to move, but where's the $2 million house go to? And so we'll talk about that and why this has become an issue. This is a stat here of 9,000 elder abuse cases. This is from a couple years ago, actually, but this is per year that San Diego County, the district attorney, is handling. Now, these aren't all financial elder abuse, but gosh, that's a lot. 9,000 cases, and that's just from a couple years ago, and it's increasing. In fact, the San Diego County district attorney has a special division specifically for elder abuse. And so they have instructed us, all attorneys, and I'll have the number at the end of this, that if you see this, report it, and they want to hear from you. that they ask that we talk to other professionals who have a chance, like, like CPAs, like realtors, people who are out in the field who can see this and they can report it when there might not be someone else to report it. So if you see it, please contact the district attorney. But what we're going to talk about here today isn't necessarily that terrible part of the physical elder abuse. We're going to talk about financial elder abuse. And the first thing I'm going to talk about it is with respect to capacity. I'm going to talk about capacity first, and then I'm going to go into defining what elder abuse actually is. And I do this for a reason, because I think it's important for you to think about. Probably the most important thing for you isn't defining what financial elder abuse is. It's determining what capacity is, because that's where I think really you come in. So this is where it starts with, is everyone's presumed to have capacity. This probate code 810A is that everyone is presumed to have capacity to to make decisions for themselves, right? That's kind of the starting point, is they can contract, they can make, decisions about their health, they can make everyone can make decisions about their life. But if that presumption is overcome for some reason, there's the next 3 sections in the probate code talk about the criteria for assessing that capacity. That if that person can't make decisions for some particular reason, the court does, and the court can make decisions for people. And there's a number of things that go into this, and I won't read every single one of them, because it reads like the list of every subjective factor you can think of. But what I think it's important for the context of a real estate transaction is to talk about what I would call contractual capacity, the ability to contract. Because let's be honest, you're not making the life and death decision of whether to do this medical treatment or that medical treatment. What you're most focused on as a realtor is, do they have the capacity to enter into a contract to sell their home or buy their home? But most of the time it's selling, obviously, right? If they're an elder, they're typically downsizing and selling the home. But sometimes they're buying. I've had transactions where 95-year-old people are buying new homes, and they they have perfect capacity to do it. But what we're talking about is contractual capacity, and these are really the criteria for it is if they can understand the risks and benefits of the transaction. That's really where it starts. And you think, well, what does that mean? The risks and benefits. Do they know that they are 95 years old and they're taking a 30-year mortgage? Who's going to, it's not realistic that they're ever going to pay off that mortgage. Are they taking do they understand that by selling this, they have to move? I mean, we get situations where people, didn't think they had to move. I'm going to sell my home, and that should be a red flag, if you will, that they don't understand what the risks of the transaction are, that they might actually have to move if the transaction's completed. And these are so the characteristics of a lack of capacity this is what the court looks for. And this again is in probate code 811, is they look for the alertness and attention of the elder. So we're talking about their orientation to time. Do they know, what time is it? What time is it? What time are we meeting? Where are we? Orientation to time and place is really important in there. Their concentration. Do they get distracted during your conversations and forget what they're talking about? And that really goes in information processing. Their short and long-term memory. Do they recognize familiar things? Do they appreciate quantities? This is something that is kind of abstract thinking, but when people lack capacity, they have a real hard time with appreciating quantities. Okay, it's 1.5 million. What does that mean to them? Are they talking about are they talking about things that have no relation to the amount of money that they're spending? And so that's really a red flag of lack of capacity, that they have no appreciation for the amount of money that's at issue in the transaction. Now, they might think it's a lot. That's fine, but not having an appreciation, thinking that $1 million is the same as $10, that is an issue. The thought process that goes into it. Are they repeating themselves? The ability to modulate mode and effect. Do they have the ability to are they always angry? Are they not? Can they go up and down? And the ability to do that, in a transaction is extremely important, because there's a range of emotions. So the issue that you're really looking at is, does this deficit in the elder, does it correlate to the decision in question, significantly impair their ability to understand the consequences of their action? Do they really know what they're doing? It sounds simple, but this is a whole cognitive test of whether they're able to understand the transaction. And this is really where you come in, because you're the one meeting with them, right? You're the one that's going into their home. Well, you used to be able to go into their home, but you're the one who is meeting them and having to assess this. And you're probably thinking, well, I'm not a doctor. How do I possibly assess this? And you're right. You're not required to, play doctor in these roles. But what the code and what the California law does require is that you're alert to these potential symptoms and try to get assistance with it. And so let me jump into what the definition of financial elder abuse is, because I think that'll help. So what is financial elder abuse? And the definition is so broad that it should scare you. And this is the part where I think it scares you. And so here's what it is. It's when a person or entity does or assists, and I highlight that for just a second, does or assists in the following: takes, secretes, appropriates, obtains, or retains real or personal property of an elder for a wrongful use, or with intent to defraud, or both, or by undue influence. So let's read that again. Let's kind of parse that out. So when a person, let's use a real world example. Son stealing from mom, right? There's five brothers and sisters in this family. Son number one, the wants to take this home from mom. So that person takes it for a improper purpose, or for a wrongful use or intent to defraud the mother, right? Or he takes it by undue influence. And you're thinking, well, that's just him. He's the one responsible. But that part I highlighted, or assists, means that if you assist him in doing that and take overt acts to assist him, you can be liable just the same way that he can. You assisted him. And so that's where this gets scary. And that's why I do this presentation at all. Because let's be honest here. Most of the time, even in the egregious situations, the realtor or the CPA or the attorney who's ever helping and is assisting isn't necessarily taking it for themselves, right? You're selling real estate. You're not buying the home from them. Now, if you are, that's a problem too. But you're generally assisting. They want it. You were told they want to sell. You're selling, right? You're getting a great offer. They got top dollar, and you're thinking, well, I did my job. I got top dollar for this home. I got 100 over listing. This was the record in this neighborhood. What do they have to complain about? Well, did mom have capacity to sell? Did that money all go to son? And was son signing papers for her? Was son saying, oh, mom wants to sell? Well, guess what you can catch? You can catch a financial elder abuse lawsuit because you assisted in son taking those funds, essentially, or in selling that home, or sometimes in just moving mom. And so that's why we do this presentation, is to really hammer that point home, that it's not just taking it. I mean, you can do your job perfectly in terms of the actual sale itself and still have committed financial elder abuse. So I want that to be as clear as I possibly can, because as I said here, it's also can be the person who assists in the transaction. So I've kind of focused on the fraud, right? The fraud of the wrongful use or intent. I mean, it's kind of, let me parse this again. Saying someone's an elder, 65 and up, that's easy, right? That's easy we can just look at a driver's license to figure that out. The wrongful use, that's also somewhat of an easy to, the wrongful use or fraud, you can kind of understand that too, right? That's an easier analysis. But what about undue influence? Because it says, or by undue influence, right? So what does that mean? Because that's where I'd say where like the gray area is, right? Everyone knows when like someone steals a property, that's fairly easy. But how do we know when someone unduly influences someone to get property, right? So that's the thing, like persuasion, right? They're persuading mom to sell the home. It's not that they like literally went in and forged documents, right? It's they influenced mom to do it, right? And how does that work? So what is undue influence? Well, it's defined just like financial elder abuse. It's the excessive persuasion that causes someone to act or refrain from acting to overcome their free will and results in inequity. So that's a key in inequity. And that could be, the 5 siblings and one of them gets it. And that was against mom's wishes. Mom's wishes were that everyone shared, or maybe there was some formula that she had. So is this overcoming her free will? Her free will was to give it to everyone. Her free will was to stay in that home until she passed away. Is this person overcoming the elder's free will? And it results in some ill-gotten gain or some inequity. And sometimes, the inequity could be small. Sometimes it's huge. Sometimes it's the entire house. Sometimes it's just some portion of it, right? But that's what undue influence is. And so there's factors that go into what undue influence is. And this is really what you should be looking at in terms of, the factors of the undue influence. Obviously, the vulnerability of the victim, right? Are they under emotional distress? Did their spouse just die? What's their age? What's their education like? What's their, the capacity that we talked about? Do they have the ability to communicate? The less the more vulnerable they are, the more susceptible they are to undue influence, right? And then what's the influences of parent authority? That gets into an area that I often see with realtors. They're like, oh, well, this person has the power of attorney, right? Oh, they told me they have power of attorney. And I ask them, well, have you seen it? What does it say? Have you taken it to an attorney? What is, I could write a power of attorney on a napkin right now and force mom to sign it. Am I saying that you have to vet these things? No, but it's possible you do in the event that you have these other factors in play. Who is the trustee? If there's a trust, who's the actual trustee? Are there any other children? What's the apparent authority of this son who says mom wants to sell her home? Look at the actions or tactics taken by the influencer. This is what undue influence is as well. Are they the gatekeeper? Mom can't come to the phone right now. A lot of the cases we see, and we often unfortunately see them when mom or dad passes away and another sibling comes and says, well, this was undue influence, or we get the case where they're suing someone for undue influence. And one of the claims often is, well, in the last 6 months, when mom changed her will, or she changed her trust and changed the beneficiaries, son wouldn't let her come to the phone, or, that they would say, she's not available today, or, they would act as the gatekeeper. Oftentimes with her in their own home, they'd act as the gatekeeper for that person. And of course, what's the equity of the result? Who's getting the money? Who really wants to buy or sell in this transaction? So here's another slide that I think is important. because it's actually, it sounds maybe counterintuitive, but the actual mild cognitive impairment are the most vulnerable. Because if someone's real, has real cognitive impairment, really severe, I should say, not real, but severe cognitive impairment, it's somewhat obvious to everyone, right? The cases that are the most difficult are the mild cognitive impairments, but they can be the most vulnerable. The ones who really don't have an appreciation that they think they have capacity, but they really don't, or they're sliding down the scale. And that's where it gets difficult for you. And it also is the recipe for disaster. Like I said, the severe is pretty easy, and the people who have no cognitive impairment are easy, but it's the mild that is the most difficult, because oftentimes they will say they have capacity. What are you talking about? I can't make my own decisions. Of course I can make my own decisions. And then you go along and you're talking to them about the sale of the property, and then 30 minutes later, then you talk about something else, and then 30 minutes later they say, "Why are you here again?" That could be the mild cognitive impairment that it's starting to manifest itself. And that's the type of thing that needs to be diagnosed by a doctor, unfortunately. And but these are the other factors here. Obviously, influencing the change in one's estate plan with an unnatural gift. All of a sudden they're giving one person this, something incredibly valuable, that is like a caretaker, the caretaker scams, or it's some friend of theirs all of a sudden is getting a massive gift when that wasn't the estate plan that they had put together for the last 20 years. Poisoning the mind of elders against others, and isolating them. This is that whole that issue I was just talking about with the gatekeeper issue. Financial scams, obviously, the speculative transactions, let's buy gold, let's buy this, let's buy that, and without an appreciation of the risks and rewards. We get a number of these where these are speculative transactions that are out of character. Like here's a good one. I had one a couple of years ago where a 90-year-old man, they said, let's develop this parcel. Let's buy this parcel on spec and let's develop it. And in the next real estate cycle, in the next 5 years, we'll put a bunch of houses on this and we'll make a ton of money. Well, why is, the red flag should go off in your mind. Why is a 90-year-old man speculating in real estate? Now he can, if that's, I'm not saying he can't do it. But the red flag should be going off that he's never speculated in real estate before in his life. Here he is at 90 years old speculating in real estate on a risky transaction that's going to take years to make any money. Who's really benefiting from this, right? Is he really benefiting from this? Is he going to even see this? Is he going to even live to see the rewards here? And so it's scams that have that kind of that sinister speculative transaction that's out of character. These are the types of undue influence we're seeing, and you can probably see it in your practice. If you're seeing someone doing something like that, an elder has no experience in real estate, isn't a real estate developer, all of a sudden, some friend of theirs is now getting them into a speculative real estate investment without the proper protections. Without let's do a carryback note where you give me 4 years interest free, and then we'll share in the profits. And the red flags should just be exploding in your head or waving back and forth that this is not a good transaction for someone who's 90 years old to do, and they may not understand the risks of something like that. So I'm going to show a couple examples now, real life examples. I'm not going to spend a ton of time on these, but just showing you that there are actual cases out there where the assistance of financial elder abuse has come to have real liability. So this one realtors always love, because it's the lawyer getting hit with it. And here's an example of a case where and this can happen. Elders lawyers can be part of the problem. And in this case, the lawyer was getting a finder's fee to a mortgage broker who was a real estate licensee, essentially as a kickback. And that can be financial elder abuse, right? There was no reason for a finder's fee in a transaction like this. And if you're seeing something like that on a transaction where they're out of escrow, they're sending this, or they have plans to send some other gift to someone who's supposed to be a representative, and it's essentially an unnatural gift, right? This isn't giving a gift to a grandson or a granddaughter to go to college. This is giving a $4,000. In this case, it was only $4,000, but I've seen higher. Giving a fee or some type of referral to that either came out of escrow or not out of escrow to someone that can be a red flag of that something, some abusive scheme is going on here. Here's another example of an elder abuse, a financial elder abuse. This was the signing of escrow instructions. I don't know how many times we have to say it, but don't sign documents for your clients, right? You've probably heard that. That's somewhat of real estate 101, right? But you'd be surprised at how many people still do that. They sign on behalf, or they say this person told me to sign, or there's some ambiguity between whether they signed. But knowing that signing, here, the signing of escrow instructions in this transaction constituted financial elder abuse. And you could see it. I don't think it's, as much as you signing the instructions, right? But what if son is signing for mom? That's an issue that I've seen before. Is mom will come into your office and with son, and then son will say, well, I'm going to sign for her, do the listing with me, or maybe even worse, son comes to you directly, right, and says, I want to sell my home, and you say, okay, great, let's sign the listing agreement. It's 123 Elm Street. Wonderful. We're going to start selling this. And then you look at title, and son isn't on title. It's his mother, or it's his deceased father, or whatever it is. Or maybe he's not the only one on title, right? Maybe he's on title, but so is dad. And where's dad? Does dad want to sell? You say, oh no, I can sign for him. Well, he may be committing financial elder abuse in that transaction. And guess what? By accepting his signature and proceeding with that transaction, you may be assisting with financial elder abuse, right? Which has the same liability. When we define financial elder abuse, has the same liability as the person who's actually doing the signing, who may be defrauding dad out of his property. Now you're thinking, well, at the end of the day, doesn't the escrow have to, they're going to have to verify who this person is. They're going to have to come to the house. They're going to have to do a notarized signature. But yes, but at the same time, guess who's going to get sued? If you get all the way to that point, and that's the gatekeeper, and sometimes it isn't. Trust me, that as much as we trust notaries to verify, they're not there assessing the cognitive abilities of the person who's signing. They're just looking at the driver's license. Oh yes, that's Russell. Yes, okay, sign. They're not at that stage, right? But let's even assume that they were the one who stopped it, right? That son couldn't produce dad to sign the documents because maybe dad's deceased, right? Or maybe he just can't sign. Well, guess what's going to happen if you get all the way to that stage? That buyer who's been under contract, who's expecting to move into that home, they're going to sue for specific performance. And guess who they're going to sue? They're going to sue seller and they're probably going to sue you. And they're going to sue you saying, how on earth did you get us all the way into this transaction, through the inspection, through the waiver contingencies, through the deposit, through 30, 40 days of this transaction. I spent all this money getting ready to move. And then you're telling me you didn't even know who your seller was? Did that fall below the standard of care? I would think you might have a problem there. That might be a real issue that, did you ever meet with Russell? When did you meet with him? What did he say? Did he actually want to sell this home? Things that, there's going to be some uncomfortable questions that would be raised, even if it was caught. God forbid it wasn't caught, and Russell did sign and didn't have capacity or didn't want to do it. That could be, that could be another problem. So, then there's even more damages perhaps. But either way, you have a pretty strong risk of ending up in a lawsuit, with the family or with Russell or with the family, maybe with the buyers. I mean, there's a lot of risk there. And it can do something from merely as signing escrow instructions or merely signing a contract for someone. And I paint this scenario because I think there's a lot of risk in it when family members are coming with that elder, or they're saying, I'm authorized to sign for them. Trust me, I have power of attorney. Don't worry about it. I sign everything for dad. And that's not what you should be doing. You shouldn't be accepting that at face value, that they sign everything or they have power of attorney. I want to see it. I want to talk to their attorney. I want to talk to the person who drafted. I want to make sure. And the way, and I completely understand. Let me kind of back up. I completely understand that if you challenge son on something like that, that son may get upset with you, saying, what do you mean? You're calling me a liar that I don't have the power of attorney. Why do you want to ask to talk to the attorney? And I'll go to some other realtor. And what I would say, as with my lawyer hat on here, I would say, okay, go to some other realtor, because I want to protect I, as a realtor, I want to protect my clients, my reputation. I want to make sure everything's by the book. And if someone isn't comfortable giving you access to the attorney to make sure that it's by the book, what are you doing? Why are you taking that listing? You shouldn't be taking every listing if it's something like that. The same way I don't take every client. Every client that walks in to White and Bright, we don't take. For the reason is that I want clients that are truthful. I want clients that are going to be honest with me. And if someone's not going to give them access to their attorney to see how they prepared the power of attorney and whether this person does, has been assessed by a doctor that they have capacity, then, maybe you pass on that listing, because that should be a red flag to you. And I'll talk about that in the agent tips as we go through this. But let me give you another example. Here's an example where they didn't even, it wasn't necessarily a sale of a property, but this was a lot line adjustment where, this is a fairly complex transaction in Northern California, but essentially what they did was they, through the fraudsters, if you will, did a lot line adjustment of a parcel, which reduced the size of it. And then, they took that parcel. And so, they were supposed to take a smaller parcel. They ended up doing a lot line adjustment, take a larger parcel, and they did it to an elder. And because they did it to an elder, and the elder was unaware of this lot line adjustment, which actually was quite valuable property, because it was part of a community that they were going to build, they needed it. It ended up, being financial elder abuse. So it wasn't even necessarily a traditional real estate transaction. If your work, and I bring this up because if you're working on something with, let's say that there's multiple lots and they need to help with an adjustment, or they need to help, do something that isn't necessarily a sale, that can be financial elder abuse in itself. And you're thinking, well, I didn't even get a commission on that. Well, it doesn't matter, right? Did you help did you assist in an elder losing, having their property taken from them? So there are situations where you didn't even have a transaction, and it could be in the property management. Could it be in property management where maybe maybe the father owns a number of properties, and the son says, well, I'm taking over his finances. Why don't you send the rent checks to me? He needs it. I need to hold the money so that he can pay his bills. Well, this isn't a transaction, right? You're just changing the bank accounts, right? Son can do that, right? I don't think so. So be very careful of the influence of family members. So I bring this example up here because it doesn't necessarily have to be the purchase or sale of real estate. It could be something revolving, or involving real estate, like a lot line adjustment. So what are the consequences of, we've talked about we talked about somewhat extensively here what examples of these types of transactions are, and the problems that can occur. But what are the consequences? What happens if you do get sued, or there's a claim against you for financial elder abuse? Well, let's start with the easy one. There's civil penalties, right? So you certainly can get damages against you, and that's for instance, let's say $200,000 was taken. Well, $200,000 in damages, right? So they can go after you civilly. But here's the one. The next one is the one I really want you to think about, because this is the gnarly one. Is attorney's fees and costs. It's been drilled into a lot of people, certainly attorneys, but for those of you who've had claims before, it's been drilled into you that attorney's fees and costs can be huge in transactions, right? And oftentimes, in a lot of claims, attorney's fees aren't available, or if they are, they're only available to the prevailing party. You probably told your clients that, well, you're in a real estate, we signed the RPA. If you do get sued for a non-disclosure of material facts, for instance, they're going to go after attorney's fees, but the attorney's fees are only available for the person who prevails, right? The winner of the lawsuit. So you got to go all the way through the lawsuit to the end, and whoever is deemed to be the winner can conceivably get their reasonable attorney's fees back. Well, there's a modification to that for elder abuse transactions. They are one-sided attorney's fees. So if I have a case, if I'm an attorney and I bring an financial elder abuse case against you, my client can get their attorney's fees if we win, but I don't have to pay them if I lose. They're one-sided, right? So what have you done? You've incentivized attorneys who don't need all that much incentive. You've incentivized them to sue on these transactions because they're low risk, right? What's the worst they do? The worst they do is they're out their own attorney's fees. And so there's actually a lot of attorneys who take these on contingency. They'll take financial elder abuse cases on contingency, meaning that they don't charge the elder or the person representing the elder anything unless they win. Because if they win, they can get these damages, they can get it and their attorney's fees and costs back. Oh, and guess what? They can get punitive damages too, because this is a species of fraud. So they can get treble damages. So that $200,000 claim you had, they can now get $600,000 on that with the punitives. Oh, and let's say they had $200,000 in attorney's fees. All of a sudden, that $200,000 claim is now $800,000, or it's $1 million. And so you can see how sometimes a small claim can get huge with those incentives of penalties, punitive damages, and one-sided attorney's fees and costs, which is rare. There's very few statutes in California that allow for that. For instance, environmental is another one. But financial elder abuse is one of them, and why it's frankly an expanding field of law is going after financial elder abuse. So if that doesn't scare you, this next section will, is that insurance often doesn't cover this. So the insurance that you have may cover, may defend you in some of these cases, because oftentimes they'll allege things like negligence as well, or breach of fiduciary duty, the traditional things that your insurance, hopefully you have insurance, will typically pick up that defense. But often if you get hit for financial elder abuse, that's not going to be covered in the end. Remember, there's two parts to an insurance policy. One is their duty to defend you, to provide an attorney who represents you. We do that. There's other firms that do that. The insurance companies often like to pick their own attorney who works exclusively for them. But they often do appoint an attorney. That's called the duty to defend. But then there's also the second half of your policy is, okay, what if I'm liable? Who pays that judgment? And it's probably been drilled into you that, well, maybe your negligence claim will get paid by the insurance company if you lose, but your fraud won't, right? If you're shown to commit fraud or forgery or something like that, that doesn't get paid by the insurance company if you lose, right? And financial elder abuse is the same type of thing. So if you get hit for this, so that $800,000 judgment that we just talked about a second ago, that would be uncovered. Imagine that, right? Imagine getting you didn't even take the money, right? You just you were assisting somebody else. You thought you did a transaction. You got $30,000 as a commission. All of a sudden you're staring at $800,000 in potential liability. That's scary. Uncovered by your insurance company. Oh, and if that wasn't bad enough, there's criminal liability for this. It's actually a crime to commit financial elder abuse. That you can go to jail for this. It's depending on the severity of it, it can be a felony, which, as you know, a felony is defined as a year in jail and often a fine. So there's real penalties here. These are not theoretical. These are not, oh, this will never happen to me. These are real. And not only are they real, real downside, but it also gives the plaintiff in these cases tremendous leverage, right? That gives it, if they're bringing an action against you for financial elder abuse, they have a lot of leverage to go after you, and a lot of leverage to try to get you to compromise your case to some extent, because you're scared about all these things, like these parade of horribles that can happen to you. So, scaring aside, what are some agent tips? This is kind of the conclusion of the presentation here, because I want to give you realistic things that you can do to protect yourself, and then I'll give you some resources where you can get some more information on this. But I want to preface this, and I know I have the whole slide here so you can kind of see where I'm going, but I want to preface this with, you don't have to be an expert on elders. You don't have to be a neurosurgeon or someone who is trained in assessing capacity. But what you are is you're somewhat of the gatekeeper, right? You're the person who can prevent the harm, because the person who's getting abused or is someone's trying to take advantage of them, they don't often go to that neurologist, right, on their own. And so you have this unique ability because of the role you play. Attorneys somewhat do as well, and so do, and certainly think people like CPAs and accountants, they have that, and obviously caretakers can do it as well. Although they have this unique ability to be able to assess the capacity and try to get help for that person. So these are really the keys. And things that are recommended. And some of these, not only come from, the cases, but also from people like the district attorney who has opined that these are the ways that you can help in a transaction and really help yourself. I mean, part of my presentation here today is to help you. I don't want you to get a claim for financial elder abuse, and to help your client, right? You want to support your client. So here are some of the things. Meeting with a client in multiple settings and at different times of the day. people have always heard of like the sundowners, people who, when it, that they're at, the end of the day, they have less, they're less alert than they might be in the morning. So meeting with the client at different times of the day in different places, let's meet at this location, let's meet at that location. You may get them out of their comfort zone where you can assess whether they really understand the transaction when they're in unfamiliar settings, for instance. Because you can see a baseline, you can see sudden changes in behavior. If you meet with them in the morning one day and they know everything, and then you meet with them, the next day at 5 o'clock in the afternoon, and they have a completely different behavior, that there may be an issue going on there. That's something to assess. I know it's obviously kind of hard right now with the coronavirus to meet with any elders, and it makes your job particularly hard. But my hope is this goes away fairly soon, and that you'll be getting back to the normal meeting with a client in their home. Maybe you meet them at a restaurant. Maybe you see them in different times of day, and so you can assess you can assess them in different locations. And I would also add to this, meeting with them alone, right? Meeting with them without son in the room, without daughter in the room, and talking to them in that context. And if son or daughter says they can't do that it's impossible, I don't want you meeting with mom all alone, what are we doing here? Red flag, right? That's a red flag. The way I would describe it to them is, as I'm trying to protect you. I'm trying to protect you, daughter, because we don't want to have a claim. And I that's the way I describe it to them. And if they still can't understand that, there's probably a problem going on there. Another thing to protect yourself is to keep accurate records of your visits, conversation, and steps to assure capacity, right? And this is something you might not do with your regular practice, but anyone who's ever taken a webinar from me, I tell them document, document, document. I have a slide that says that. Always document your conversations. I know it's a pain, but the cases that I don't get, the cases that don't become lawsuits, are the cases with well-documented files. The ones that we do get cases, and the liability cases, are ones where, oh yeah, we had a conversation, but I didn't document it. Oh yeah, I just texted them, said see you later, or I said okay, we'll do that. It's just a quick text. It's not that. But they don't have the accurate record. So especially with an elder, documenting, okay, we came here on this day, we talked about this, we talked about how, she wants to move into, this assisted facility, and she's going to hire so-and-so to move her stuff, and document all that. And you might think, well, isn't that overkill? It's not. It's certainly not in these transactions. And one of the reasons, and this sounds really cynical and really and sad, but oftentimes, by the time the lawsuit's filed in these cases, the elder has passed away. And so there's no one to testify that you had that conversation, right? It's just your word against what? But if I have contemporaneous notes that were, on March 23rd, I talked to Betty, and we talked about this and how she wanted to use, this transition company. And we did, and she was and her son was going to come visit her that day, and she wanted to give some money to her grandkids to fund some trust. We talked about all this stuff, and I have those written notes. Gosh, that's going to be good evidence. I'll tell you right now, as the attorney, I would love to see that if I was defending you from a claim of financial elder abuse, that this is the conversation you had. Here's a memo to the file. Here's an email confirmation that was sent to Betty. I would love to see that. And that's the type of thing that you should get in the habit of doing in these elder transactions, if you're not doing it already. I mean, I'd love to see it in every transaction, but especially in a transaction where I may not have the other person. I may not have the person you talk to as a witness, right? I might be going off of, nothing, right? Just the documents that were signed in a shaky hand, right? I'd much rather have it in a different context. The same way that when we have in my office, when someone comes in who is an elder and there's an issue of capacity, often we'll either send them to a neurosurgeon to get an opinion, or not a surgeon, but a neurologist to get an opinion as to their cognitive abilities, or we'll have another attorney who will come in who will also do an assessment. So getting that belt and suspenders can only help you in these types of transactions. Signed consents for the client to communicate with other third parties. Don't get me wrong, in a lot of these transactions, they will say, I want my son to handle this. I want you to communicate with him. I don't have an email address, or he checks his all the time. I want him to help me in this transaction. I want him to do the inspections and some of the repairs. I want him to be responsible for that. That's fine. An elder can do that in those types of transactions, but get that consent and sign, get that waiver, get that in writing that you're going to communicate with son. But ultimately, father is going to be the one in charge here. And that's the situation where, I would say consult with your broker, consult with your general counsel as to what that looks like. Consult with their attorney. They may have their own attorney, or they should be getting one. Right? There's enough money involved in some of these transactions that they should get an attorney involved, right? And if they refuse to do that, it's probably one of those situations where you got to do a double take. Is this client worth it? What am I walking into, that these guys are selling a $2 million home, but they won't pay a couple $1,000s to do this correctly? Right? They won't pay a couple $1,000s to make sure we have the correct waivers, make sure we have the right power of attorney, make sure that the trust is up to date. That's just a red flag that should be shooting off alarm bells again in your head, that we're doing this massive transaction, but a few $1,000s is a bridge too far for them. What else is going on here? And lastly, develop your own protocol to handle the difficult issues. Some of these difficult issues are, what I've kind of talked about, which are questioning them. And it's somewhat uncomfortable because people I get it that it's so competitive in the industry right now that you hate to turn away someone who's ready to sell, right? This is like gold. It's like gold bars right now, that if someone's ready to sell, you hate to turn them away, but you at the same time, you can't walk into an elder abuse, and commit financial elder abuse. And so creating your own protocol to handle these issues and to question people the way I couch it is, I'm trying to protect you. Like if I'm talking as a realtor, I'm trying to protect you. I don't want you to get a claim for elder abuse. Or I want to make sure this is by the book. We do everything right. And here's what we have to do. We have to question, why are we selling? What's, where are you going to live after you sell? Ask those questions, create your own protocol to handle those difficult issues. And then a great one is to challenge the elder at the end of the meeting about a question at the beginning. So I've heard this many times, where this is the recommendation is to talk about something lighthearted, or like what their grandson is doing. Where is he going to college, or talk about some aspect of the property, even like the garden or something of like this particular rose bush, and then sit down for the rest of the half an hour or hour, and then at the end of the transaction, or the end of that meeting, go back to that story that they just told about their grandson, or go back to that rose bush and see if they remember it. And if they don't, that's, you have an issue, right? There's an issue that probably is coming up, because apparently that is a very good way of assessing the short-term memory, if they can remember the beginning of their trend of their meeting at the end of their meeting. But developing your own protocol to handle these issues is recommended, and you can use a lot of the things that we talked about here today, or I talked about here today. So I know I said that this was be an hour, and we're right at the hour, but I do want to have one last slide for you. And this is that number that I said I would provide, because there's other types of elder abuse other than financial. I said today we were going to only talk about financial elder abuse, but obviously there's other types of elder abuse. Certainly abandonment, the false imprisonment, and a lot of these go hand in hand with financial elder abuse. That's why I'm bringing it up. The physical abuse, psychological abuse, isolation, and this is the number to call if you're seeing any of these things. The district attorney has implored me to tell you to call them, to not either call the sheriff's department or call the district attorney directly to report this. That you can be a hero in this. You can report these things. That if you're seeing this coupled with financial abuse, because again, these things often go hand in hand. Someone who's being physically abused is often being, they're often stealing the money too. And so if you're seeing these go above and beyond the financial considerations of what we talked about today, these things that need to be reported, and certainly financial elder abuse needs to be reported as well, but these as well. So, and with that is my presentation for today. Hopefully this was helpful to you, and that if you do have an elder transaction, you will consider these issues, and you'll really look for this. Now, if you are entering into this transaction and you have questions, always consult with your broker. That's what they're there for. General counsel sometimes for the firm can also help on these transactions. It's very important that you protect yourself and you protect your client who could be that elder. So if you have questions, feel free to ask them now, or if you want to follow up with me later, there's my phone number at White and Bright. There's my email address. I'm more than happy to always talk with you. Some of you I may represent already. Some I've represented in the past, or my firm has. Some of you we may represent in the future. So feel free to reach out as necessary. I will take a look. Doesn't look like I see any questions on the chat. But if anyone wants to jump in, feel free to do so. And I don't know what I did with my screen here. Okay. Well, doesn't appear that there's any questions. Oh, there's a chat there. Oh, thank you. Well, thank you guys for attending. I hope, like I said, I hope this was very helpful to you. Please give me a call or shoot me an email if you have any follow-up. But it was nice seeing you all, and this is the best way to avoid lawsuits, is to get this type of education. So I think you're doing yourself a real service, and you're doing your firm a service. Feel free to bring this back to your firm, to your colleagues, so that they know when they're dealing with elders what they're supposed to be doing. So thank you, everyone. Appreciate it. And I'll see you soon, hopefully in person. Exciting to do that soon.